Hi guys, welcome to Sheria. Sheria is a platform whereby we educate the common mwananchi on the law with the aim to equip you and empower you. Karibu sana. My name is Maina, an advocate of the High Court of Kenya, and today we are going to talk about arrests, specifically the rights of an arrested person. The rights of an arrested person are captured and provided for under Article 49 of the Constitution of Kenya, 2010. So, umeshikwa. What rights do you have? We all know the Miranda Rights. Hizo za majuu. You have the right to remain silent. Anything you say or do shall be or can be used against you. And surprisingly, they have been captured in our constitution. Yes. Number one, once you're arrested, you have a right to be informed in a language that you understand. Meaning, kama huelewi Kiswahili, huelewi Kizungu, and you are maybe a Kikuyu, they should find a person who can translate to you as soon as possible in the Kikuyu language why, one, you're being arrested, two, that you have the right to remain silent. You don't have to speak. Even when you're questioned, you don't have to say anything. And that three, anything you say in that moment can be used against you. That means umeshikwa and unajua out of panic, ushaanza kuongea, kujitetea. Whatever you say can be used against you. Now, what happens after that? You have to be given an opportunity to reach out to either an advocate or a family member, basically anyone who can offer assistance to you in that situation. So, umeshikwa na wanakupeleka police station. You can ask, I need to call my advocate, I need to call my sister, I need to call my spouse, my husband, my wife. They need to know where I am and what is happening to me. And that's your right. Now, you also have the right to be produced before a court that is established under the Kenyan Constitution. So, depending on whatever crime it is utakuwa charged nayo, you'll be produced before a court within 24 hours. That means kama umeshikwa Monday, at least by Tuesday, unafaa kuwa umeproduciwa before the court. So why is it important to be produced before a court of law? Because it is there where you'll be charged. What does that mean? You'll be told, okay, so this is what you have done. This is where a charge sheet is usually prepared. What does a charge sheet contain? Among other things, it contains, number one, the crime that you have been told umecommit. So itakuwa kama ni tuseme theft. Itakuwa imeandikwa hapo stealing section so and so. Then kutaandikwa pia the particulars of that crime. What does that mean? How it happened, right? So and so was at this time on this day caught doing this and this. That's very important. So that's the importance of heading to a court. At least, hautakuwa umeshikwa na haujui umeshikiwa nini. And also, you don't even know the crime that is against you. Therefore, you don't even have a chance to do something about it. The other importance of heading to court is, it is at that point you can be given bail or bond. And in the event it is denied, they will have to adduce enough evidence to show why it is important for you to remain in custody. So what does this mean? So umechukuliwa na umepelekwa court and the prosecution reads out the charge sheet. So and so has been charged with this crime. This is what happened, particulars of the crime, the date, the time, and such things. So the court will look at the crime and then they'll give a bail or a bond. That means after they have issued that, you can be released upon payment or producing that kind of bond to the court. So they can say, for instance, toa 200,000 ama atatoa 20,000 depending on the crime, right? And utaachiliwa, utakuja kusikia kesi yako on such and such a date. Now, there are times where the prosecution will say, apana, this one cannot be released back into the public. And the court will have to ask the prosecution to give evidence, mbono usiachiliwe. So the importance of going to court is that you remaining in custody will be a legal thing after you have gone through the hands of the court. because the court will ask the prosecution, give me evidence. Mbona tusimwachilie? And maybe the prosecution may say something like, this one is a flight risk. Meaning wewe, unajulikana maybe uko na ndege yako, ukiachiliwa tu hivi, you leave and they'll never see you again. Also, maybe because you have committed this crime so many times and they know you have the ability to go and do it again. The court can also factor in maybe if they release you, you're a person who has a tendency to, or depending on the conduct, you can be able to reach to any witness that could be used against you, to testify against you, and maybe threaten them or harm them in any kind of way. Those are the things that the court looks at. But that rarely happens, especially in issues of petty crime. It is the right. The arrested person has a right to be produced before the end of 24 hours of the next court day. Meaning, if you're arrested on Friday, you have to be produced by Monday. So one may also ask, what happens if Monday imekuja, hawakunipeleka, Tuesday imekuja, hawakunipeleka, Wednesday ni hiyo, hawajanipeleka? Are you stuck? The answer is no. An arrested person who's in custody has the right to petition for an order of habeas corpus. Now, what does this mean? The court will give an order, leteni huyo mtu kotini. So you'll be produced before the court and you'll be able to be charged and given a chance to pay bail or bond to be released. Or if enough evidence is produced and the court is convinced, they can withhold you in custody. This is where you now move to, in this country, to now the remand and wait for a fair hearing. So you have been arrested. It's either you have remained in custody or you have been released on bail or bond. What happens? Every person who's been arrested has the right to a fair trial. What does a fair trial entail? It entails, number one, being presumed innocent until proven guilty. One cannot, for instance, be taken and held in custody together with those who have been convicted and are serving a sentence. Also, the court has to listen to you, not from a perspective of a guilty person, but from a perspective of an innocent person, until the prosecution is able to prove that you're guilty. Number two, one has the right to be informed of the charges, and not only the charge against you. Si kuambiwa tu, wewe uliiba, wewe uliua. You have to be given the details of those charges. Nilikuwa wapi? Nani amesema? Ilikuwa siku gani? Saa ngapi? Niliiba nikapeleka wapi? So all those details have to be produced by the prosecution, which brings me to my third point. An accused person has the right to be able to be given time to prepare their defense. If they have produced certain evidence against you, there are probably papers and so many other things. They have to give you enough time to be able to go through that evidence and form a case for yourself. Number four, an accused person has the right to be informed of the right to have an advocate. And in the event one cannot afford an advocate, the court appoints one for you. Who does the work? Usually pro bono. So what happens if in the middle of the whole trial process, either who you advocate hatokei, they're not even telling you of the dates, you have no idea what is happening, you have a right to be able to address the court and let them know that your representation is no longer doing it effectively. And it is at that point the court may appoint another advocate for you. An accused person also has the right to a quick trial. What does that mean? The trial should be done quickly, without delays. There are situations whereby either you are not produced in court or the prosecution is dragging the situation. As the accused person, you have the right to address the court on this and make them aware of the fact that the matter is being dragged too long. Now, we have all heard, I plead the fifth. What does that mean? You have information which you do not want to state because maybe it can be used against you. So in Kenya, an accused person has the right not to state or give any information that may seem self-incriminating. Adjacent to that, we have the right of the accused person remaining silent Yes, an accused person can remain silent throughout the entire trial process, and that's okay. An accused person also has the right to have an interpreter present during the trial where the person maybe cannot understand the English language or the Swahili language, to have an interpreter at no cost during the trial. Also, it goes to show that the accused person has to be present. Unless the conduct of the accused person is wanting, it will prevent the trial from proceeding. For instance, maybe they have outbursts of, shouting and causing chaos. In that situation, the accused person can be removed from court and the trial process can continue in their absence. Meaning, witnesses wataingia, watoe ushahidi, hata kama yeye hayuko, and the court will still be able to make a sound decision. The trial has to be conducted in public, that means in the court that is established under the Constitution. An accused person also has a right not to be charged with an offense which she or he has been already acquitted of or convicted of. Kama ulikuwa umeshikwa na ukasemekana umeiba kitu fulani kutoka kwa, Paul stole from Moses. Paul haizi tena shikwa tena, na saa hiyo alishaambiwa hakuiba na koti kasema hapa hakuna kesi, enda home. Haizi kuja tu kuchukuliwa tena ati aliiba hizo vitu tu tena, because the court has already acquitted you. Also, kama Paul alishikwa na yenyewe alikuwa ameiba vitu za Moses and akaenda na either akalipa ama akaserve some time in some jail time, haizi kuja tena ashikwe for the same offense, achajiwe for the same offense juu he was already convicted na aliserve. So you have been arrested, you have gone through a fair trial. So what next? If you are convicted, that means you're found guilty and convicted. At the time of sentencing, wewe uko na right ya kupewa the minimal, the least, yani ile yenye si uchungu sana, yenye imeprovidiwa under the law. So sema there's like a minimum of 5 years. There's a maximum of 20 years. So you have a right to get that 5 years, depending on, of course, the decision of the court. So again, the court has found you guilty. You have been convicted. What chances do you have? Number one, you can appeal. What does appealing mean? It means taking your decision, alafu unapeleka kwa a higher court. Say you are found guilty in a magistrate court. So unapeleka high court and you tell them, go through these facts again, go through this evidence again, and then go through the law. Muone yenyewe, this court, this lower court, walikuwa wrong kunifind guilty. You can also apply for a review where that court decision inaangaliwangwa tu tena and then a decision is made. So it can be varied in one way or another. So this accused person, again, has a choice to apply for a review or to go for an appeal. It is important to note that you cannot do both. You can only pick one. When it comes to an appeal, one can appeal 2 times. So the first time you'll apply to, of course, a higher court. Say you are in the magistrate court, you'll apply to the high court. And the high court will be able to look at, number one, the facts, and they'll also be able to look at the evidence and the law. Say it also doesn't go your way in the high court, you can still appeal the second time to now the court of appeal. So what happens in the court of appeal? They will only look at the law. So they rarely, or rather they do not look at the facts or the evidence that was produced. So you'll only be able to go there kusema, court, watu, they didn't follow the law. This is what the law says, right? So they went against this particular law. But hautaenda kusema, hiyo sikuwa hapa, nilikuwa hapa. They won't deal with that fact. They'll only look at the law. So those are the 2 stages and the differences in the 2 stages of appeal. What about evidence yenye imeletwa in an unlawful way, has been obtained in a manner that is not lawful? For instance, you have been accused and someone else is maybe bribed or threatened to come and testify against you. Or we have evidence, maybe of tangible things that do not actually form any evidence in that, or should not form any evidence in that particular case. The moment the court realizes, or it comes to the realization of the court that that evidence has been obtained illegally, it jeopardizes the entire trial process. This means the trial process can begin from the top. I hope you have learned something today regarding the rights of an arrested person and an accused person. I do hope you enjoyed this episode. Remember, if you're watching this and you're yet to subscribe to our channel, please click the subscribe button below. Also, share a comment, write something about what you have learned, ask a question about this topic or any other topic, and don't forget to share it with your friends. Knowledge is power. That's all for today from Sheria. I do hope you enjoyed. See you next time. Until then, be blessed.